Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We hold these two weekly calls every other Thursday where we try to answer the questions posted by our community members. And we answer them to the best of our ability. As you would have heard when you logged in, that we do the best we can in the time that we have. This is definitely not a substitute for an in-depth consultation, but at least we'll be able to point you in the right direction as it appears from the facts that we hear. Okay. I'm going to begin as usual first with the frequently asked questions. Ask for any follow-ups on the frequently asked questions. These are questions that I have marked. In my view, these questions are being asked time and time again. So we just want to make sure we cover these first. After which I will then go into answering the posted questions that are not frequently asked. And if time permits, we will take new questions. My first frequently asked question today, sir, is from Mr. Kumar. My wife currently, effect of H-1B approval on H-4 EAD. So wife is on H-4 EAD, valid till October 2020. By the way, you must have heard the news that the government has said that they are not going to be able to get to even try to revoke the H-4 EAD until spring of next year, which means something like April, May of next year. And even then they are not sure. And I think part of the reason is that there is just not enough reason to try to take away H-4 EAD. There is no rationale in a sub 4% unemployment economy where employers are hurting for people to work, for Trump administration to come and try to take away people's right to work. So we'll see what happens. So H-4 EADs are good for now. Now she's got her H-1B approval starting October 1st, but she wants to stay on H-4 EAD. Does the law permit her to work on H-4 EAD even after her H-1B is approved? Or would her work visa convert to H-1B automatically? So I think, first of all, you need to understand that within the H-1B approval, there is a sub-approval called change of status. So when somebody's H-1B is approved, what government is saying is, okay, you qualify for an H-1B. Your job has employer-employee relationship. It's a specialty occupation. So all the usual criteria for H-1B are met. But the second part, which is the sub-approval, let's put it that way, is the physical change of status from, let's say, H-4 to H-1, or more frequently, F-1 to H-1. That change of status is what converts you. Approval of the H-1 does not convert you. To give you an example, I have a client, I just got off the phone with him today, who had a J-1 that needs a waiver. So when we filed his H-1 under lottery, I said, look, I cannot file for a change of status because you require a waiver of 2-year home residency requirement. So we got his H-1B approval, but we've got it approved consular processing. So he went from J-1 to F-1, and he's currently working on STEM OPT extension. So the point is, even though the H-1 is approved, his OPT is still good for another 2 years. He can continue working on that, because what we have for him is a determination by the government that he's entitled to H-1B. He has to go for visa stamping or reapply for change of status to H-1. In your wife's case, the key question is, does she or has she received a change of status? If the change of status has been received, it will be effective only October 1st. Now, this is where things get murky. I believe that reasonable interpretation of the law would say, if you withdraw her H-1 before October 1st, she will continue to be on H-4 EAD. But the government has to receive the request as quickly as possible. In my view, that's how it should work. But here is the problem. If government disagrees with my interpretation for whatever reason, I can't see why, but with this government, I always worry because they come up with extreme interpretations of the law that are against common sense as well as precedent. In fact, we have another client who has just filed a lawsuit or in the process of filing a lawsuit in Minnesota against a very odd determination. So the problem with her could be, Mr. Kumar, that if you withdraw her H1 and the government says, okay, well, we acted on your request on October 25th, so she already has her H1, there's nothing we can do about it. By revoking the H1, H4 would already be gone. You are losing both things. So here's what I think should be the practical solution. Have your lawyers or her lawyers contact USCIS, explain to them the problem, and if you are willing to take a risk, go ahead and have the H1 revoked. Also make sure that it gets done over the phone as well. So in writing as well as the phone, and I think that should work out. So if a change of status does not take effect, I think you would continue to be in the old status, which is H-4 EAD. So act quickly before October 1st to revoke or withdraw your H1, your wife's H1. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question on this. No new questions, please, just a follow-up. Okay, let me go on to the next frequently asked question. So there are a couple of sub-questions within this question from Fani. I had to travel to India because of my father's serious health condition. H-1B amendment is in process. I want to travel back. I have moved to my current employer in April and I have approved H-1B for 3 years. Because I am changing client and location, amendment is filed. I don't have stamping. So the question is, there are two sub-questions here. One is, can I get back into, first of all, can I travel out while my H-1B amendment is pending? The answer is yes. When you have an H-1B transfer, amendment, or extension pending, and you were maintaining H-1B status, you just need a visa to get back in. Traveling abroad outside USA, when you are doing an H-1B to H-1B process, such as amendment, extension, transfer, is no problem. So that's the first question. The second part of the question is, can you use some other employer's H-1B? And the answer is, I don't see why not. We've had this discussion with the consulate. The consulate told me, no, you cannot. And I showed them their own standard operating procedures. They clearly say that you can use a visa granted in the name of another employer. So the answer is, you should be able to travel and you should be able to use the visa of the old employer. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a question that follows this one. No new questions, please. Okay, so let's go on to the next frequently asked questions. For him, how many years is the H-1B quota exemption valid? So the question here is that I live in Mumbai. I got an H-1B approval, got a visa stamping also, but didn't come back. Now the question is, how long am I exempt from the H-1B? In between, somebody else filed, they got their case denied. Doesn't really matter. Bottom line is, the law says you are exempt from the H-1B quota if your H-1B has been approved anytime in the last 6 years. So 6 years, for 6 years, you are exempt from the H-1B quota. Okay. There are many sub-variations and sub-complications to this major theme. One of them is, let's say I'm approved from 2013 to 2016. Is it 6 years from 2013 that I'm exempt from the quota, or 6 years from 2016? So far, government has taken the position that it's 6 years from 2016, the date to which you were approved. But they might revert back. In any case, you've got 6 years if your H-1B was approved anytime in the last 6 years. Another thing you have to remember is something called the remainder rule. The remainder rule works like this. Normally, if somebody leaves the United States after being on H-1B and they are gone for 1 year, they can reset the H-1B back to 6 years. So let's say you were in H-1 status in USA and worked for 4 years. Then you left USA and you were in your home country, let's say Italy or India, for 1 year. You have two choices. You can either come back without the quota problem for 2 years because you had already used 4 years and you got 2 years remaining. Or you can say, since I've been outside USA, I want 6 years back, but then you have to go through the quota system. That's called the remainder option. This may or may not be applicable to you, but I'm just pointing it out to the gang who's here, to the community who's here, just so that you folks know there's something like that available. Keep it in the back of your minds. *5 if you have a follow-up question. So yes, sir, you don't have to go through lottery. Go ahead. *5 if you have a follow-up question on this. Okay. I see a lot of people, at least 4 people logged in from India. I was wondering if it's... okay. Next is New Andhra says, can a person working on green card EAD work 100% from a remote location, like a different state? Why not? They can. The only problem is, well, there are 2 problems. One problem is the I-485 follows your state of residence. So you must file an AR-11, a change of address form, and you should contact your lawyers and see if they recommend moving the 485 according to your residence. The second problem is, remember, your green card, and I don't know how it was filed. Typically, most consulting green cards will be filed saying that work can be performed from any unanticipated location. So in cases like this, I don't see any deleterious effect on the green card. As a practical matter, once you have your green card employment authorization through 485, you can work from any location you like, as long as you clear it with your lawyers, make sure there are no complications, and as long as it does not interfere with your green card, which at least I can't think any green card filed in our firm would accommodate for situations for consulting jobs where work can be performed from any location. And I think that's true for almost all lawyers, because this is not a new situation where you have 6-month project here, 8-month project somewhere else, and you keep moving. So in those cases, your green card application, your permanent application will say that work will be performed at various unanticipated locations throughout the USA. In cases like that, you should have no problem at all with your green card, even if you decide to change locations. But please double check with your lawyers. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next frequently asked question. So this is something that has come up very frequently, and I've answered this question at least 10-15 times in the last few years. Should I maintain my H-1B after filing I-485 adjustment of status? And the short answer is yes. I like it very much. In the beginning of this call, I had mentioned a client of ours whose I-485 has been denied on a very flimsy ground. He's in Minnesota. So he is filing now an appeal / lawsuit against the denial. The only reason we are not concerned about his well-being is because we had told him to keep his H-1B active, which he did. Now, while his 485 is being contested, he doesn't have to worry about status. He's not accruing unlawful presence. He doesn't have to leave USA. If he leaves USA, does his 485 get canceled anyway? So it becomes very complicated. In my view, if you have an option during 485 pendency, keep your H-1B active and alive. So to take Ladol Patel's situation, the community member who's posted this, employer A has filed a green card. Employer B also filed. Now it is already more than 180 days after filing through B. My company is acquired. Transaction will end. My current company will be dissolved. What happens if I get laid off? You should follow the 60-day rule to file another H-1. I think it'll be a good idea. Can I join with EAD? you can, and then you can file an H-1B transfer. The only thing is you'll have to go out for visa stamping to activate your H-1B, which is not the end of the world. You can do it at your own convenience. But keep your H-1B filed and approved, so if necessary, you can go and get an H-1B visa stamping and come back. I just explained to you what the advantages of maintaining your H-1B are. If your company gets acquired, do they need to refile H-1B or green card? Well, green card, no, because you would qualify for AC-21 portability. H-1B, it depends. If they are a successor in interest, they don't have to refile the H-1B. That's a legal and factual determination. Somebody has to look at your papers, the transaction, how it was taken over. As a rule of thumb, if a company acquires assets, substantially all assets and liabilities, or stock, or a discrete unit of another company, and they continue doing the same business under the same terms as the old H-1B, an amendment or any kind of new filing should not be required for H-1B. For green card, it would be different analysis. So overall, you will need to go hit your lawyers for this, but none of this looks unmanageable. Okay, *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question. Very well. Let's go on to the next frequently asked question. And this is for a unmarried gay couple. One partner is getting a non-immigrant visa, and let's say the other one wants to come with them as a common law partner on J2. I haven't specifically researched this issue, but this is what I believe would be the situation. If you folks are coming from a jurisdiction, let's say you're coming from the Middle East, where they don't recognize same-sex marriages, obviously you cannot get married. If you were married, you would be entitled to a J2 visa automatically. You can apply for it. But as a same-sex couple who cannot get married, your spouse or your spouse-to-be, your better half or other half in the couple, can actually help you apply for a B2 visa. And this is a well-known use of B2 visa. If you go to Foreign Affairs Manual, look at the chapter 9, I think it's section 42, but it's definitely chapter 9, 9 FAM, available online. There is actually under B visa, there is a use of B visa where somebody does not qualify for whatever reason as a derivative, but they are still given a B2 visa. This is a typical example. Another example would be if there is a parent who needs taken care of and somebody's here on H1, they want to bring their mom or their dad. They're not qualified to get H4 because that's only for spouse and children. Government is inclined to issue tourist visas, and you can keep extending that as long as the H1 is alive. So that's a well-known use of B visa. So I would recommend you look at B2. Once you get here, of course, you can get married and convert it to J2. That would be a way to do it. Another way to do it would be to get married in a jurisdiction close by where gay marriages are allowed and where they will allow non-residents, non-citizens, etc. to get married. So as long as the marriage is legal, it does not matter which country it was done or performed in. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next frequently asked question. I don't think we have any more. Oh yeah, we have another one. This is impact of multiple pending H1 cases. Well, first of all, as a generic matter, let's say you're on H1 already and 8 companies file for your H1. All 8 get approved. You want to join company number 3, that's okay. You want to join company number 5, that's okay too. You don't want to join any of these companies and stay with the old employer's H1, that's okay too. The only consequences are if you have any contract liability, that should be discussed with lawyers Normally, H-1B cases are not allowed to be put in any kind of recuperation mode. So in other words, employers should not be able to recover their normal business expenses from you. But in any case, immigration law-wise, multiple H-1Bs pending at the same time, where a change of status is not an issue, could not be any problem at all. In your case, you got laid off from a company. I-140 was approved. Current H-1B expires in 2020. You are an ERP guy. Okay, one thing is, if you're approaching for contractual work on H-1B, that's not possible. You have to be on a W-2. Can you be on multiple W-2s simultaneously? Yes, you can be, but you have to file concurrent H-1Bs for that. I have an MBA and an MS from a top-ranking US university. I'll be getting regular full-time work in 3 to 4 months. I'm curious, if I have multiple H-1B approval requests, does that jeopardize my chances? Not at all. Not at all. I hope this answers your questions, Jay. If you're on the phone and you have a follow-up question, press *5. If something is not clear, okay. So this question is coming from, I see your hand up. This is coming from Wisconsin. Okay, Wisconsin, go ahead, please. Wisconsin, go ahead. We can hear you. Hello?
Can you hear me?
Yes, I can hear you. Go ahead, please.
Yeah, Rajiji, this is Jay. The person who's filing for my H-1B transfer is going to start the process tomorrow, and my 60 days goes up on the 8th of October.
Okay.
So can I start work at receipt of the application, or do I have to wait for approval to start work?
No, you can, as long as you have not worked without authorization and your H-1B is received within that 60 days and your I-94 is still valid past those 60 days, you can start work as soon as the papers are received by the USCIS.
Okay.
All right.
All right. Very cool. That's all I had.
Good luck.
Thank you so much.
You're welcome.
Yep.
Okay, so let's go on to the next question, frequently asked question. Okay, I think that's pretty much it. Now let's go on and start from the very beginning and answer those questions that were not frequently asked questions. This one is from Apollo123, who says, I have H-4 status while spouse is transferring H-1B and earlier company withdraws H-1B. I-94 is expiring soon. So the situation is this. The question comes from the H-4 holder. My I-94 is expiring in 10 days, September 29th. Currently on H-4 visa. Spouse had filed H-1B and H-4 from company A, also transferring H-1B to company B at the same time. Well, my first question to you is, why don't you have company B also apply for H-4? It's a little bit of an overkill, but it's a protection. As long as it gets filed with him, I think that would be a good way to do it. Because your concern is, if his H-1 is filed by company B, but they don't file my H-4, and the old employer who had applied for H-1B, H-4 together withdraws the H-1B, wouldn't I be out of status? And the answer is probably you will be. I think you will be. Okay. So I think it would be a smart thing, a practical solution, if you do not wish to travel outside USA, to go ahead and file for an H-4 through the new employer as well. *5 if you have a follow-up question on this. *5. Okay, let's go on to the next question. Harsh says, I'm currently on H-1B good till 2021. Fiance's OPT extension is good till 2020. She's going to start a second master's, which allows her CPT from first day. Folks, I want you to be aware, government unless they get sued, are going to go after your CPT. They have been saying that CPT, OPT combined, leaving aside STEM OPT, cannot be more than 12 months at any one educational level. So if in a master's degree, master's in information systems, you've taken 3 months of CPT, you only can get 9 months of OPT. And if you join another master's, because it's the same level as the first master's, which is master's, you won't get any CPT or OPT, according to them. I have a serious problem with this interpretation, but they are thinking along those lines. And if they decide you are not in status, they'll make you go outside USA for visa stamping. Okay? So, leaving aside that issue, you want to get married on October 11th. Congratulations. After marriage, does she have to change to H-4? No, she does not. Will she face any issues because she doesn't change to H-4? I don't think so. Will my fiance face any issue when employer files for H-1B next year? I don't think so. Do I have to make an amendment because of marriage? You do not. Will I face any issue in the future if they file my green card? Not at all. So the marriage does not affect either one of you in your immigration status, but it gives your spouse, and I'm assuming it's a she, the option to convert to H-4 if she so chooses, but not the obligation. *5 if you have a follow-up question on this. *5. Okay. So we've done these 3 frequently asked questions. Amar Singh says, 2 separate employers filed for my H-1B quota case. Both were filed as a change of status. Both were approved. Change of status was approved for both. Old employer is the one I started working for using F1 OPT. I already began working for a new employer using the remainder of my OPT and sent my manager from the old employer my resignation. I noticed that my H-1B from the old employer says your case has been approved. Should I email them and ask them if they can withdraw it? It's been 2 to 3 weeks since my resignation. The answer is yes, you should. And you should also make them aware that withdrawal is required by law, otherwise they have to pay your salary. It is a violation of immigration law. Now, do they owe you the duty? Probably not, but they owe the system the duty. So, Department of Labor and even USCIS has agreed with them, has said, if you want to, or if somebody leaves your employment, if you want to terminate their employment, you must revoke their H-1B also. So yeah, I think putting it in writing would be a good idea. You're not required to. I don't see why this is your problem. They can leave that H-1B hanging. You're working with another employer anyway. But if you want to keep the record clean, I don't think this is a dirty record anyway, but if you want to somehow keep it all tied up neatly, you can let them know and let them know in writing. You want your H-1B withdrawn. *5 if you have a follow-up question on this. *5. Okay. So question number 9 we have answered, 10 we have answered. Those were frequently asked questions. Nisarg says, July 2018 applied for H-1B amendment plus extension, normal processing. Before my I-94 expired, 28th February. Also filed family-based I-485 on 19th February, again before the I-94 expired. Good. My H-1B got denied, but you have a 485 pending, which was timely filed. If due to any paperwork, if my 485 is denied, then can I reapply the same? Well, I don't know what kind of family-based case you have, and I don't know all the answers off the top of my head. Many, like for example, spouse of a citizen, or you're not a minor child, but minor child of a US citizen, would not have any problem reapplying the 485 after denial. Okay. I would also recommend like I told some other people, you should apply for an H-1B transfer or extension, whatever you want to do. File it again, even if it got denied. And meanwhile, you've got your 485. Somewhere along the line, if the H-1B does get approved, you can go to Canada, Mexico, or your home country, I'm assuming is India, and get an H-1B visa stamp. So even though you used your EAD, by getting a visa stamp and coming back using that visa, you would be back on H-1B and your 485 can go on parallelly. Star 5, excuse me. Star 5 if you have a follow-up question. Okay. Let's see where this question is coming from. This is coming from Illinois. Yes, Illinois, go ahead, please.
Hello, Rajesh sir. So, I think I discussed this case personally with you in the month of July.
Oh.
That I filed a family-based I-485.
Okay.
I presented my receipt to you. So it's a family-based in F4 category, brother sister category.
Okay.
My only question is I am staying here based on I-485.
Right.
And if I am not sure for any paperwork, there will be a chances of denial or not. So that's what my question is.
Nisargji,
Something-
it is so difficult to say how things will work out. So, being a
Okay.
person who gets paid to be paranoid, I would rather cover you from every possible angle. I think what you should do is,
Okay.
don't work until you have your EAD. Make sure you work after you get your EAD. In the meantime, if the
Yeah.
employer is so willing, refile your H-1B. I would like you to have that active as well, just in case something goes wrong. Okay?
So even though my I-94 expired, can I file my
Yes,
H-1 again?
yes, because you are in legal status, what is called authorized period of stay because of the 485.
Okay.
And what you are doing is, you are
Okay.
getting the H-1B approved and putting it in your back pocket to get the H-1B visa stamping whenever you feel like getting it.
Okay.
The
But
moment-
I am not sure
One-
since
one
my
second.
I-485 is
One second.
pending.
One second. Let me
Yeah.
just finish this. So as soon as you
Okay.
get the H-1B visa
Okay.
stamping and come back, you are back on H-1B and your 485 can also continue.
Okay.
Okay.
Okay. So I mean, as my I-485 is pending, I'm not sure if I will be allowed to travel outside.
Yes, because
of,
you should apply for advanced parole. You will be able to travel on your advanced
Okay.
parole, right?
Right. Okay.
Yeah, this is a situation
Got it.
we encounter all the time. So this isn't something new for us. This is a very common theme in our cases.
Got it.
Okay.
Okay.
Good.
Thank you.
Good luck, sir.
Thank you, Rajesh.
Oh, you're welcome.
Yeah.
Okay. So next question is Akshay. Oh yeah, Akshay, I'm so sorry. I've had no time. In fact, this afternoon I was going to start a book or an online book inviting everybody to post their questions on it. I actually have not been able to answer questions on our own website for months. No time. I'm working almost 7 days a week and very long hours. So this morning, actually, I told our front desk that you have to stop taking so many calls for me every day. I have so many appointments. Some days I start working at 2 o'clock in the morning because it's just so busy. I enjoy the work. I do it. I don't have to work. I do it because I really love it. But it's just become impossible to do all these things I want to do. So I do want to start this for you guys. This discussion on public charge, how it relates. Like I told you the last time when we were on the call, that this issue only comes up when you are applying for a green card. It should not affect you in any other way, applying for a green card or a non-immigrant visa. So, but in any case, I do owe you that. And I'm hoping over the next few days, because I've just told Marty at the front desk that please don't make appointments past 1 o'clock. So I'm just going to do 5-hour appointments. After that, I have a little bit more time. So I'm hoping I also review cases and, maybe help with drafting, etc. So it becomes difficult. The days become very long. My average day is probably, I don't know, about 14, 15 hours. That's almost 7 days a week. But I'll still find time. I want to work on this. One, because everybody needs to know a little bit more about public charge issues. And two, because I myself want to know more about it. Although we don't have this come up in our practice very often, but I do need to learn more about this. So if you have any question, Akshay, there's nothing else I want to add, but if you have any question or if you have any comments, press *5. And I do owe you an apology. I've been meaning to do it, just no time. Akshay, I think I see you on the phone. Do you have any questions or any comments? Press *5 on your phone. Oh, okay. Yeah, I thought that was you. Yeah, Akshay, I can hear you. Go ahead.
Yeah, Rajiv, I'm actually Akshay's mother.
Oh.
And me and my husband, we both are on green card. That is what Akshay wanted to know about the public charge, because we are on Medicaid.
Gee.
And but we are on Medicaid. I'm on Medicaid since 2014.
I will definitely do it. Over the next 2-3 weeks, I'm gonna get into it. I'll lay it all out for you. Okay. So sit tight.
Okay.
Don't give up on it. I will look this up for you. Okay.
Yeah, because I think the cutoff date is October 15th.
Gigi, I understand. No, I understand. I'll have it up and ready for you before then. No worries.
Okay. So when should we expect that?
Before your cutoff date, you'll have the information. That much I can promise you. Okay.
Yeah, I just wanted to check on that.
No
because
worries.
that's why we came up again this week. No point coming up again next week, right? Because you'll do that.
I will do it. No worries. Okay.
Okay. Thank you.
You're welcome. Bye-bye.
Okay. Bye-bye.
Yeah, I'm just so annoyed that there are not more hours in the day. So many good things to do. Okay, so let's go on to the next question from Hitendra. I got my first fresh H-1B visa in 2000 from employer A. Okay. Worked for 6 months, then went back to India. Then I changed my job to another employer, filed fresh H-1B. I worked on this visa for 1.5 years, then went back to India in 2005. 2008, employer C, I came on L1A, around 3 years. Then went back to India in 2011. In 2014, so that means your clock has been reset, my current company filed another L1A. I worked for 3 years. Then I got L1 first extension in September 2017 for 2 years. I worked for 1 year, returned back to India in May 2018. Is my old H-1B cap exempt? The answer is no, because it was more than 6 years ago. Way more than 6 years ago. Yeah, no. Well, can you do this is one thing I'm not very clear about. I actually have not thought about this long enough. The interesting question here is this, Hitendra ji. What you're saying is, so in 2005 I left, I had only used, let's say, a year or 2 years of my H-1B. 10 years later, can I reclaim the remaining 4 years without going through the quota? And I can only make a guess because I have to spend some time thinking about what the law and the policy says. This is a remainder option question. And my guess is, and I could be totally wrong about this, please have somebody look at the law carefully. My guess for you would be this. I think that the remainder option works only if you are still within 6 years of the H-1B approval. Once you go past 6 years, you don't have a choice to reclaim your H-1B remainder time. That's my guess. *5. Okay, one more question. Can I transfer L1A used only for 4 years? Oh, yes. Through other company, if you qualify, absolutely. You still have 3 years left. And I think during those 3 years, you should make a plan to either apply for an H-1B again and then also at the same time start a green card under EB1C. Because remember, L1 cannot be extended past 7 years just because the green card is pending, but H1B can. So, and it doesn't disturb your green card. So, your lawyers should be able to guide you in that. So just keep that in mind, that definitely you can get an L1. Definitely you should also apply for an EB1C green card, and definitely each year you should try to get back onto H1B, because then if the EB1C goes beyond 3 years waiting, you will keep extending your H1B. *5 if you have a follow-up question, Hitendraji. *5. Anybody has a follow-up question? Okay. So this one is probably a voice over IP because I can't tell where it is from. Go ahead. I can hear you. Go ahead, please.
Hello, Rajivji. Namaskar.
Namaskar ji.
I am currently basically in India. So I just wanted to, I am actually resigning from my current company,
Okay.
Which is having L1A.
Right.
So if I can get, is it possible to transfer from L1A to H1B if I get another employer?
If you go through, you have, let's say, in the last 6 years, you have used 4 years of L1, so you only have 2 years of H1B left. Okay. Unless, well, you left USA on May 2018, so you've been gone more than a year, right?
No, my H1B was only in 2000 and 2003.
No, that's
After
not what I'm
I
asking.
have
No,
two L1A.
Hitendraji, that's not what I'm asking. What I'm saying is, when did you leave USA after you had the L1? Did you not leave May 2018?
Yeah, right.
So, May 2018 to May
I
2019. One second. You've been gone 1 year, right?
Yes.
Okay. So that means you have 6 years of H1 and 7 years of L1 back if you want it. Okay.
But I have to go through lottery.
You have to go through lottery.
That's
That's what I think. But I haven't researched the law. As I said, is there some wriggle room in the remainder option that allows you to recapture the time that you have remaining even past the 6 years of H1B approval? I don't think so, but law is full of surprises. I do not know for sure. Okay.
So Rajivji, can I get that answer, or
I don't have time to research. No, have your lawyers do it for you. If I had the time, I would be happy to do it for you, but I don't have the time. So I'm already committed. You may want to have your lawyers, whoever you choose to work with, they should research it for you. They should let you know. I won't have time to do that. If I have the answer off the top of my head, I'll be happy to share it with you, but I don't. Okay?
Okay, thank you.
You're welcome. Good luck.
Thank you so much.
You're welcome, sir. Okay, so then this is a question from Rich ML. I'm working on an H1B visa. My current employer, Company A, got I-140 approved. A is about to file 485. I want to continue working with them indefinitely. So I don't know what's going to happen to my job. The Company A is in trouble, or may be in trouble. There's another Company B who wants to give me a job in the same area. I want to work for both employers at the same time. So if my current employer fails to continue as a business, or my current job with my current employer does not exist, I can continue to work for B. The logistical challenges of working for two employers is something that I would be able to take care of. Yeah, personally, I don't see any problem. Let me give you an interesting example. I've given it to many people many times. I had a client some years ago who was holding 3 full-time jobs simultaneously. When I filed his third H1B, government questioned me. They said, how can he be working 120 hours each week? Well, his job was such. So his job was that he was a senior database administrator. So once he set up your databases, all he had to do was carry a pager or carry a cell phone so that if the employer needs him, they can call him back. Initially, setting up the databases, setting up the environment, setting up the boxes, the parallel processing, or the virtual environment, all those were a lot of work. But once it was up and running, He just had to be available, and he got paid for being available. So if practically you can hold 2 jobs, I don't see why not. Am I violating any rules on H-1B? No, you just have to file a concurrent H-1B. My understanding is that the job offered to me in Form I-140 remains a bona fide job offer that I intend to accept. Am I violating any rule filing of 485? No, you're not. No, you're not. The only thing is, I would not feel any necessity to indicate to the government that I have apprehension about the continuity of my job. That is none of their concern, and it could become a problem for you if it actually was brought to the government's notice, because they could start saying, well, we don't think this job is permanent or it is offered in a bona fide manner. I think it's an unnecessary problem. If after 180 days my situation does not change and I apply for job portability to a new permanent same or similar job, would I be able to retain the 485 filed by employer A? Yes, you will be. I cannot deny working for B because I would lose the job offer. I may be able to use the job from company B to request portability. Yes, certainly. I don't see why not. It looks okay to me. *5, if you have a follow-up question on this, *5. Okay, so let's see where we are coming from. This is from California. California, go ahead, please.
Rajiv sir, thanks for the clarifications. In answering the part 1, the first bullet point answer, you said the H-1B should be filed concurrently.
Right.
What does that mean? The employer A already has my H-1 approved.
So
B has an approval.
The way it works is, let's say you have an employer A's H-1B approved. You don't need to touch that if you're not changing any working hours or job description with them. But if you want to simultaneously work with another employer, you have to file that second H-1 as a concurrent H-1. Okay.
But it has already been approved.
You have to do it again. If they did not file it as a concurrent H-1B, you cannot work on 2 jobs simultaneously. Okay.
Oh, okay. So it should have mentioned that it is a concurrent H-1B petition.
If you look at the form I-129, there's a specific box you have to check. It says, is this a new petition? Is this a transfer? Is this an amendment? Is this a concurrent H-1B? Okay.
Oh, I see. Okay.
All right.
So it has to mention it is a
Absolutely. So just refile it, premium processing. You can start working concurrently once it is filed with the USCIS, but it has to be a concurrent H-1B. Okay.
Oh, okay.
Anything else?
There is no other alternative.
No, there is no other alternative that I know of. You can also, you can probably also do this, and I don't see any law that stops you from doing that. You can start working with employer B and have employer A amend the H-1 as a concurrent H-1.
Oh, I see. Okay.
One of them has to be concurrent with the other. Okay?
I see. Okay.
Good luck, sir.
Is there time for one more question?
Yes, if you make it quick, because I have about 12 minutes and maybe about 3-4 more questions to answer.
So if I travel outside of US and come back on the H-1B stamping of employer B, the new one, but I can continue to work.
It doesn't change. Doesn't change the problem. Still the same problem. Okay?
Okay.
Good luck.
All right. Thank you.
You're welcome. Okay, so let's see. Oh no, next one is frequently asked question. The one after that is from Jerica. And this is a very odd situation. What happened with her was she had applied for an H-1B under lottery for consular approval. And it got approved, and she traveled while it was under processing. But the attorneys accidentally withdrew the LCA. Okay. So, Jerika, I think you would have lost your quota placing. Because if you have not received a change of status and you have not received a visa stamping of an H-1B, I don't think you can be exempted from the H-1B quota. So I think you probably have lost your place in the quota. I don't know. I haven't researched this issue. I would have to review the law and see if there's a way to save the case. But I think because you did not do consular processing visa stamping or got a change of status, your H-1B was destroyed before October 1st could come and you had done these things. I think you are back in the quota. And yeah, law firms can make errors. We do too. I hope not as many times as some other law firms, but occasionally, every 1 or 2 years, I've seen a problem occur. And we go in and fix it, hopefully not hurting anyone's career or life. But it can happen. Nobody's perfect. So, can you take legal action against the law firm? Legal malpractice cases are extremely difficult to win. I can't comment about it because I'm not admitted to practice law in all 50 states. I can work on federal law anywhere, but I can't work on state-based law. But generally speaking, lawyers only owe you what is called a duty of ordinary care. So as long as they are careful and some mistake occurs, you can't really, I don't think you can do much against the law firm. It doesn't help you anyway. And secondly, I really don't see, if they were careless, if they were, drunk on the job or something like that, I can understand. But if it's a mistake that can be made despite reasonable precautions, I don't think you have a case. But again, I don't discourage you. Please look into it. You can talk to a legal malpractice lawyer and see if you have a case. But it's not going to help your H-1B. *5 if you have a follow-up question. *5. Okay. So, question number 17. Doing cross-chargeability. What if my wife, through whom I'm doing the cross-chargeability, is not with me in the interview and maybe she wants to even drop out the process? I don't know the answer to that question. Again, it's such a tertiary issue of law. Somebody will have to review. It's an important question. It's not an easy question to just plan around. It is an important question. I would say either pay for our time, we'll look it up for you, or have your lawyer, if you already have a lawyer, look into this issue. How far you can go with the absence of your spouse based upon whom you're getting cross-chargeability, either in the interview or even in the 485 process. Okay? I do not know the answer to that question. *5 if you have a follow-up question. *5. Okay. So this one is also from California. Yes, California, go ahead, please.
Hello, Raju, sir.
Yes, sir.
Can you hear me?
I can hear you, sir.
Okay. I heard that there is something like expedite. If I'm waiting for the interview, I can expedite it. I can create a service request to expedite it. So
very unlikely.
Sorry?
Very unlikely
Okay.
that they will give you an expedite. There is, I think, only about 6 reasons for the expedite. Government error, extraordinary hardship of some kind on the employer or the employee, financial hardship. It's not really easy to get expedites because otherwise everybody would be doing it.
Right. Okay.
So yeah,
just thank you, sir.
have it looked at, see what kind of flexibility there is in the absence on the cross-chargeability issue. All right. Oh, by the way, one more thing.
Okay.
I forgot to tell you this. Also have your lawyers look at this. What if you split your case? You do 485 and she does consular processing in Nepal. So she can go take care of her daughter, and when the time comes, she can go for green card interview along with her daughter in the consulate in Nepal, in Kathmandu.
Oh, right.
Okay, so look into that.
Okay, yeah,
maybe
I'll take a
maybe you
check,
can.
check with my
Yeah, I'm pretty sure. I'm 100% sure, in fact, that you can do cross chargeability on this. This is called following to join. So following to join allows cross chargeability. It's no problem at all. Okay.
So I don't have to go to Kathmandu.
You don't have to.
give the interview here.
You don't have
do it from there.
You can split it. You can file form I-824. She gets her interview in Nepal. You still get the benefit of cross chargeability, and you interview for your 485 here in USA.
Okay.
All right. Good.
Thank you, sir.
You're welcome. Good luck. Okay, so guys, only 5 minutes remaining. I won't have time for new questions. I still have. Oh, how the heck did all these questions come up? They added more questions. I have to talk with my team on this. Maybe not. Oh, I miscounted. Okay, well, I'm going to do my best to finish these questions. I have to finish these questions. I won't have time for new ones, guys. So this is the Nepal question. Now, R.D. Singh, Ram Singh says, applied for L1A renewal with wife's L2 EAD premium. L2 is still pending. So what do we do about the work authorization? I know that law firms are doing litigations, but it's become more of a litigation factory. And as long as it's working, I don't have any problem with it. I have actually recommended a couple of people with H-4 EADs pending for a very long time to seek those. We don't have time to take on litigations on just delay issues. It's a lot of work. Okay. But there are law firms. I know there's a lawyer here in Herndon who is doing this for a living. That's all he does. He just does litigation filings on these and similar issues all over the country. But that's their practice. Our practice is, I have a couple of litigations going on, but they're on discrete issues, not just on delay issues. Okay. So yeah, definitely explore that. I don't see why not. But I think what they are doing is they are filing 6, 7, 8, 10 cases together in one complaint. So I think they charge like $6,000, $7,000 per case, and they are doing like something like that. I don't know exactly what the exact details are, but they wait until they've got 7, 8 people together, then they file a complaint. Then they again wait until they got 7, 8 people together, then they file a complaint. So we just don't have the time to do that. We will take on litigations that have a discrete issue. For example, somebody's H-1B got denied. There's a specialty occupation issue. We'll be happy to assist you because that's a discrete separate case. It's not just a case where you have 8 people all crammed up in one complaint. And definitely if you're geared towards it, you can do it, but our law firm cannot. So definitely, yeah, explore it. I don't see why not. And it works. I'm getting this information from a lot of lawyers. Sorry, I don't know who have their hand up. If you have a new question, I don't have time for it. Unless you have something to say about what we are discussing, I won't be able to take your question because I'm running out of time. So we'll give it a shot. Let's just see. Let me finish up this question. So yeah, congressman, ombudsman, all of these options could work. Not congressman, but employer letter can work if they demonstrate some urgency or some extraordinary harm to them. We have a second filing. First EB1 was denied. Will the litigation have any bearing on this? It should not. Litigation should not affect. Litigation on an L2 EAD delay should have no effect on your green card. Okay. So if you're on the phone, press *5. I'll be happy to take on follow-up questions. Somebody has their hand up from New Jersey already. Let's talk with them. Go ahead, New Jersey. I can hear you.
Yep. Sir, my follow-up question to this is that since we filed in June last week, it's approximately 3 months right now. So how long can we wait? Because of October 9th, my wife will have to resign. So
you see,
should we wait for
what the complaints are doing is, normally when you seek relief against delays, you have to demonstrate to the court delay against what? What is the standard time for these cases? And I think one of the key provisions they are relying upon is a generic statement made by Congress that it is the sense of Congress that cases should be decided within 6 months. So I'm not sure. You can talk with these folks who are filing these cases and see if they think that they can file a case even though it's only 3 months pending. Doesn't hurt to check. And by the way, I just thought of something else. There's been a huge discussion going on in one of the American Immigration Law Association forums about L2 EADs shouldn't even require an EAD because L2 is an employment incidental to status. Okay, so you may have another approach to the litigation if you end up filing a litigation. It could be a declaration from the court that an EAD should not even be required for L2 people because it is employment incidental to status. Okay, the only reason we have been getting EADs is because it helps us fill the form I-9. So that's another approach, Mr. Singh. You can look into that as well. See if there is any traction in approaching this case as employment is authorized even if I don't have any EAD because it's employment incidental to status. Okay? Have that researched.
Okay.
All right.
And so you, if we don't do litigation, sir, should we wait for a certain amount of time and
want
then
you to
seek some recourse?
Get a lawyer. If you don't already have a good lawyer, get one, or you can contact our firm. I can have somebody try to research this issue. It's going to take a little while because it has to be tracked through. You have to look at what the Social Security Administration says. You have to look at what USCIS has said over the past few years. You have to look at these various things, what Congress has said, and see if there is an argument possible that a person can continue working without even an EAD. Okay?
Okay. Thank you, sir.
You're welcome. Good luck. Okay. And I think this is, oh boy, we still have 2 more to go. Okay. I'm running late, but we'll do our best. Let's see. So I have a question regarding the current processing time for 130, almost 25 months in California. So I am a green card holder of Canada, permanent resident of Canada. She has an ETA for Canada. I don't know what ETA means. So what they are concerned about is taking so long to get green card approval. Scenario 1, I want to have my wife keep her job in the USA. Can my wife work remotely? Oh, wait a minute. If she has Canadian work authorization, she can work remotely. There is absolutely no problem because it's not required when she is in Canada to have work authorization for USA. She's working on Canadian soil. She doesn't even have to travel. Okay. What is re-entry permit? Because re-entry permit only comes after she gets her green card. There's no re-entry permit before the green card. Oh, I'm sorry. I mistook I'm sorry. I have a question regarding I-130 processing time. How my wife? Oh, I see. Okay, now I understand. Now I understand. Okay, I think you are the one whose I-130 is pending. So that was a little confusing. Your I-130 is pending. Your wife is already a green card holder. Yes, she will need a re-entry permit. Also look at, there is a, what do they call them? Daily commuters. look at the daily commuter option, because there is a possibility of maintaining your green card. If you live in a Canadian border town and you travel to USA every day, you get a daily commuter card which you show at the custom and at the ICE checkpoint, and you have an expedited entry, and you also maintain your green card that way. Doesn't help your citizenship, your wife's citizenship, but she gets to keep her green card. So both re-entry permit as well as a daily commuter pass should be options. Re-entry permit is required if she's not living in USA completely. You should get a re-entry permit no matter what. And there are no other non-immigrant options, Ronakji. That's all you've got. Okay. *5 if you have a follow-up question. So in my view, re-entry permit is required, and I think you should look at the daily commuter option also. Voice over IP, go ahead, please.
Hello, hi, sir. This is Ronak, and the follow-up, like the question regarding that is we don't live next to the border. She lives in Chicago, and I live in a little bit far from the Canadian border. The question was earlier this California processing time was pretty quick, but now it's taking a year or more. So we were just basically looking for the other options. What are the possible options? So we were wondering if she can work completely remotely. Is it possible that she continuously work for the U.S. company where she is working right now, but do it from Canada?
Yeah, the answer is I already answered. So hang on. I already answered these questions, and the answer is yes, she can, but she should get a re-entry permit no matter what.
Okay.
All right.
Mm-hmm. And does it affect our green card processing? My green card processing or I-130?
The only requirement is when you go for your green card interview. Okay, at that time she should have moved back to USA, or she should be in the process of moving back to USA.
Okay.
All right.
That makes perfect sense.
All right. Well, good luck to you.
Thank you so much, and thanks for helping.
You're welcome. By the way, I just wanted to add two more things. How do you prove that you are in the process of moving back? One thing is you've already rented an apartment. She's already moved back. So that's the good thing is she already has a US job. So it'll be easy for her to prove that she's moved back. All right.
Okay. Right. Yeah.
All right. Good luck, sir.
Thank you so much, sir. Thank you.
Okay, now this is a difficult question from Frankie, who says he went to Delhi consulate to get visa stamping, etc., and they are asking for tax documents of the company. So question number one, does the company have the right to decline to provide company tax returns under immigration law? Absolutely. It's their information. I don't know if there is any cause of action you might have to sue them under any law. I don't think you can, but you can check with a lawyer who does contract type litigation. Do you think my visa will get approved even without the tax returns? You should work with your lawyers. There's always a possibility they can provide alternate documentation. Because if you look at the H-1B, proving the company's taxes is not a requirement, but proving the company's genuineness is. So if they can give pictures of the company premises, their office lease, their utility bills, anything that proves the company is running and is a valid business, I think tax returns should be avoided that way. But it depends upon in which context the tax returns are being asked. H-4 visa cannot be denied. That has nothing to do with your H-1 approval or denial. Okay, so H-4 visa is a viable option as well. *5 if you have a follow-up question on this, *5. And this will be the last question of the day, folks. We have to wrap up. Okay, very good. We have no more questions. It's a delight and a pleasure to be of assistance. I'll see you again in 2 weeks. Thank you all for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.